Good morning. We'll be opening the work session for the subcommittee on the bail revision bills. If you could join me for the Pledge of Allegiance before we begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As I said yesterday, today we're going to be working on the list of crimes that has been proposed to be non-PR bailable, specifically SB 252. I believe the other Senate bill deals with the same thing, but we'll look at that in a minute. So what we're going to do is we're going to go down the list as a committee, and I'm going to open it up for discussion on each of these crimes. And everyone, please feel free to weigh in on whether you think this should or should not be eligible for PR bail. Before I do, though, I would like to hear from the Manchester Police Chief, who might help us in our deliberations as we discuss these crimes, if he wishes to do so. Chief, someone's going to give you a copy of that bill that has.
I have it in front of me.
Oh, you have it? Okay.
Thank you, ma'am. I do, ma'am. Thank you. Yeah, I don't want to get into, I think I've been here before, Chairman, and offered anecdote and offered other data. And I think what I would say is, law enforcement, but more importantly, the communities at large across the state of New Hampshire, something needs to flex, something needs to change. I'm not a proponent of putting everybody into jail unnecessarily. I don't think that's the right method. But I will tell you that I'll give you one quick statistic. From May of 2022 to August of this year, the Manchester Police Department has made just under 5,800 arrests. Of those arrests, 1,500, just over 1,500 had active bail conditions at the time of their arrest. Now, those could have been bail conditions from anywhere across the state. What the data needs to be, next dive in on the data, needs to be how many of those people were previously arrested for a violent offense, perhaps the ones that are listed in this bill, and how many reoffended with a violent offense. So I think we owe that to this committee. We owe that to, at least from the Manchester side, to provide that to you. So that data is being put together now, because I think that will offer a little bit more perspective. But again, we're talking about the quality of life across the state of New Hampshire. I think it's no secret in Manchester that it's deteriorated because a lot of people that continue to reoffend and reoffend and reoffend. Where these people were out on bail, what we started doing, why the data starts in that May of last year, is when we arrest people, we now have a spot on our arrest report, are you currently out on bail? So the individual is self-reporting. And I think this committee's talked about before, kind of synchronizing that system across the state so that we know where somebody actually is out on bail. And I think that's been brought up before. I think that would be very helpful to law enforcement. I think it would be very helpful to the courts, so that we have a true understanding of where somebody is out on bail when they reoffend, so we can notify that agency so they can take the appropriate steps if they choose to do so. But again, get to the ground truth, ladies and gentlemen. I'm out there. My men and women are out there every day dealing with people who have reoffended and reoffended. It's quite frankly, it's getting old for my police officers. It's getting old for the community that I serve in. And a lot of these people that are reoffending will tell you, if you get out and have conversations with them, that they're not getting help for their substance abuse. They're not getting help for their mental health. And they're not getting help towards employment. All things that are real and that law enforcement doesn't turn a blind eye to. We fully understand the substance abuse issue, trust me. We fully understand the mental health issue. But these people will tell you that they're not getting the help they need, and that being in jail is at least a start on a path to getting well, hopefully. Sure, there's street outreach that takes place. There's many nonprofits out there doing work. But when people are dealing with mental health and substance abuse, then you're, lack of a better term, you're turning and burning them out of a police department or out of a court on some type of low bail or PR bail for multiple reoffenses. That they're not going to be in a position to get themselves help. And really, at the end of the day, I think that's what we all want, is to help people. But the current system, frankly, is not designed. It's not getting the people the help that they need. I'll take any questions you may have, but I think this bill that's in front of you, certainly these are egregious offenses that people should at least be held for a short period of time until they can get in front of a judge and let the judge make the decision. I think sometimes, we ask our bail commissioners to do a lot. They're great in the city of Manchester, I can tell you that, but I'll go a little step further. They need to get paid. All right, they need to get paid, ladies and gentlemen. Whatever that mechanism is, when I'm calling these people in at 2, 3 o'clock in the morning, Christmas morning, every holiday you can think of, every inconvenient time, and they're not being compensated, this doesn't seem like the American way to me. So I'll end with that.
Thank you, Chief. I have a few questions. It seems to me, back in the day, if you were arrested, no one from a police department would call a bail commissioner unless you had the bail money present. Would that, in your mind, if regardless of you end up on PR bail or not, you had to come up with the $40 to pay the bail commissioner for that service, do you think that that would change things in any kind of way?
I think there's probably some legalities around that we're not, I'm sorry. Thank you. I think there'd probably be some legalities around that. I think that's a dangerous road to go down, that, hey, if you don't have $40 on you, we're not going to allow you to see a bail commissioner. There's probably some constitutionality issues there. I'm sure my friends in the room would probably agree. So, yeah, did that maybe happen in the past? I'm not sure. I don't have any experience with that. But, yeah, if the defendant doesn't have $40, then generally in the past, they would go to court, and some judges at Manchester District Court would make arrangements for them to, come up with the $40. But I think the vast majority of the time, they don't present the 40 at the time of bail. The bail commissioner gives them an envelope. Hey,
Please pay me.
please pay me. There's a bail commissioner in the room. He can probably give you the percentage of the time he receives payment back, probably pretty low.
Yeah, we heard testimony on that yesterday, and it was extremely low.
Right.
With regard to the reoffending, this list of crimes that we're looking at, could you tell us what the majority or category of the crimes that these folks keep getting picked up on? I'm assuming it's not this list of very dangerous violent crimes.
Yeah, well, I tell you, the city of Manchester, homicides are what they are, right? I mean, statewide, we know what our homicide rate is, but obviously, I think that's a no-brainer. First degree assault, second degree assault, domestic violence, AFSA, FSA, kidnappings. We do get a rash of those. Stalking, human trafficking. I mean, all of these are applicable in the city of Manchester, and probably applicable across the state. Unfortunately, I just have a greater volume of them. So yeah, I think this is a start, and it's an appropriate start, but I think we need to keep having the conversation about these people that are continuing to reoffend,
Definitely.
that are not on this list.
My question, I guess, was what I'm trying to get at is, are you seeing bail commissioners releasing people on these crimes?
Yes, I am. Yep.
Okay. Does anyone else have any questions for the chief? Yes, Representative.
Follow up to the question that Chairman Roy just asked. How many approximately would you say are violent crimes that are being let out by bail commissioners?
I think that's going to be the next dive into the data that we would owe this committee from the Manchester side. So I had somebody starting working on that this morning. And it won't take long to glean that data, but I don't want to give you an answer that may be wrong. So we will get that back. I commit to get that back to this committee.
Yes. So One of the things that you said is being in jail is at least a start. And one of the things I think that we've heard consistently in this committee from folks who maintain and manage the county jails is essentially how under-resourced and understaffed they are when it comes to actually dealing with mental health and substance abuse. So I'm just wondering, what kind of a start is jail in your mind for somebody who is rearrested and maybe rearrested for similar crimes over and over again? What kind of a start does it provide?
It could be part of their plea agreement, sir, that, hey, you've agreed to plea to this particular crime for, X amount of time in the county facility, and part of your conditions are that you enroll in substance abuse, that you get mental health counseling, some community-based corrections, if you will, and that would then to effectively monitor these people upon release. So there's some type of accountability, or at least checks and balance. Because quite frankly, sir, what happens is people are released from jail, and in my city, the door opens on Willow Street, and out they go, and that's not really fair to the individual, because a lot of these people do want help, but when to your point, resources are limited. Perhaps staffing is, and we all have staffing issues in every walk of life right now, right? So I don't really accept that. We got to find a way, just like I have to find a way every day. But just to open the door and release these people with no real connections or no, hey, who do I contact? Who do I reach out to? Who's going to check on me? We're failing them as well. Because again, a lot of them want to get better, and I believe, like many, that the criminal justice system has a role in that, other than simply arresting people and putting them in jail. I'm sure the corrections folks can come in here and speak to the programs that they offer and how to properly connect with these people and how to properly track them so they're on a path to being well and decreasing the harms in our community.
Thank you.
Representative Gathright.
I don't know if this is a question for you, but you mentioned that.
I guess it's not then.
Well, you mentioned that they would, if they have mental issues or drug abuse, they sort of want to be in jail, and this is their starting point. I might understand that if it's a issue with drugs, but with mental health, I'm not understanding why that, unless the jail is giving meds. Because if they're just sitting in jail, because we literally went to a hearing and listened to a man asked to go to the mental health facility, and unfortunately could not be released to do that. So I'm just...
Yeah, I guess that specific case, but what I will tell you, Representative, is people that are struggling with mental health, and say if they're homeless or say if they're, vast majority of time, substance abuse is on board as well, unfortunately. And when they're released into the community without any type of connection back to the resources that are available, these people vanish, or they go to places that they're hard to find and hard to connect them with those resources, because the Greater Mental Health Center of Manchester perhaps had contact with them, reestablished that relationship upon arrest or upon being at facility, and then when they're released, it's hard to maintain that connection because they go back into wherever they came from, whether it's in the woods or at a homeless camp, or again, so we're sensitive to that, but trying to keep these people connected with the services that are available is the challenge. It's very difficult for every discipline. And I would imagine if somebody's in a jail and they need to get into some type of mental health counseling, I know that jails make those arrangements to do so.
And Chief, if I could, what type of services or liaison do you have with mental health at your station? Do you have a worker or anyone like that who's there, for example, during the evenings when you're busiest?
Yeah, the mobile crisis unit, that's our main conduit between police department and the mental health center, Greater Manchester. So it could be 2 a.m. that we have somebody in mental health crisis. The mobile crisis team will respond with a clinician and a peer-to-peer, and hey, this person's already a client, let's get them reconnected, or this person's not a client, let's start getting him or her connected in the best way that we can.
is that a Manchester-funded organization?
That's,
Or,
mobile crisis teams are across the state.
so it's funded by the Department of Health and Human Services across the state?
The funding,
Or controlled or organized by?
yes. Yeah. Then they're tapped out. They're going out of catchment areas and they're busy. Yeah.
Perpendicular to what Chairman Roy just asked, what pretrial services exist in the jail right now for people who are incarcerated?
That for the Hillsborough County, it's called the ACT program. I can send you the literature on that, sir. I can send it to this committee. And that's a Superintendent Costanzo, who came from Merrimack County to Hillsborough County, was lacking. Pretrial services at the Hillsborough County House of Correction were essentially non-existent. And that Superintendent Costanzo recognized that, having come from Merrimack County, and he's trying to get that right. Back to my point about every facet of the criminal justice system having a role in trying to do what we can for these people. Because again, I'm not a proponent of just putting people in jail and locking the door and tell them to have a good day. All right, I don't think you're going to find any police officer that has that mentality. Well, I would hope we phrase it that way.
Go ahead.
Thank you, Mr. Chairman. Thank you for taking my question. I want to go back to one of your very first original statements when you had given us the number of arrests and then how many of those arrests were people that had bail conditions that appeared to have been broken. Then you went to the people that were looking for help, right? Looking for assistance with the mental health or the substance abuse.
Right.
Do you know, out of those people, the 1,500 that you mentioned, how many of those, or in opinion, was receiving the treatment part of the conditions that were given? And if one, they just didn't follow through with that themselves, or was it a lack of not being able to provide what was ordered?
It's a
for
great
them to
question.
receive?
I don't have that data. That's an excellent question. I would think there's a decent majority of those people. Again, there's a lot of nonprofits and outreach, doing great work and trying to do more great work. But there's also a population of those people that no matter what you offer them, in their mind, they're not at rock bottom yet. So they're going to refuse. The vast majority of people that we deal with every day on our outreach that the police department does, along with the fire department, a good majority of those people will refuse your services, right to your face. Okay, but does that mean we give up on them? No. But how long are they going to be allowed to remain in the community to cause further harm to businesses and innocent people, where eventually we got to draw a line, and you got to, these people got to get help, or they're going to continue to cause harm. And that's the balance, right? I think that's the challenge.
May I have a follow-up? So just for clarification, you're not aware if that was part of the bail conditions was to actually receive this treatment.
No, but one standard bail condition for everybody is not to use illegal drugs or excessive alcohol, right?
Okay.
So we know that that's a standard bail condition. So
Okay.
a lot of them are violating that right out of the gate. Now, whether they're had a condition or part of their agreement to enroll in some type of program, and then could be drug court, right? Drug court has its successes, but there are some people that are reoffend while in drug court and 3 or 4 or 5 times over. So I would imagine I would hope that the courts would have that information. They could provide that to you.
Yeah. Thank you.
Chief, if there were a component that had mandatory in-house treatment as a diversion to some of these people, are you aware of even a place that could handle the number of people that you see day in and day out in this state?
In my county, Hillsborough County, I know that the population at the county facility is not what it was pre-COVID. Their numbers are down substantially, but I don't want to speak to their population. But I know they can take in more people and perhaps start connecting more people with more services. Because, again, what's happening right now on the streets is not working. And that's just a matter of general practice and living it and seeing it every day of my life.
Representative Stone.
Thank you, Mr. Chairman. Chief, from your experience under the current bail system that we're utilizing, what's the impact on the victims of some of these alleged crimes?
Yeah, great point. Yeah, especially domestic violence victims or any victim, right? A victim is a victim. And now those are the people that we hear from quite a bit, Representative, of what do you mean he or she got released? You know, especially if it was some of these crimes that you listed in this bill involving firearms or stabbings. Again, I don't want to give you anecdotes, but, you know, last week at a riot of 10 people that are arrested, felony riot, first degree assault. Thankfully the main aggressor was held. So that's good. But yeah, we hear from victims all the time. And I'll be frank with you, what I'm telling them now is to engage with your elected officials, and be vocal and speak to the people that you're sending up to Concord on your behalf, to do the state's business. Because I can only do as much as I can do. The courts can do what they can do, but again, I'm not looking for overwhelming change. I'm looking for, this is a good start. This is kind of heading us back in the right direction. And amongst all the other things that a lot of other agencies are doing to help people.
Follow-up. Real quick follow-up, Chief. Since 2018 and the implementation of the new bail system, do you feel that law enforcement's hands have been tied?
Tied? No, because I mean, we still have the ability to enforce the laws, right, that are on the books, and we're doing that. I think what you're seeing is, we operate within the left and right limits of the state laws. What you're seeing is a massive drain on the people that put on this uniform. Yes, we signed up to do this job, but when you're dealing with the same people over and over and over, it's hurting law enforcement. It's hurting, if you don't think when people consider being a law enforcement officer, especially this generation now, they do their homework a lot more than perhaps I did when I got on the job. They're paying attention. They're paying attention to what's going on in the state and what's the temperature and what are criminal behaviors, what are they getting away with, or how much are they being held accountable. So I think really there's a sense of, especially in my community, I'm 100% confident in saying it, that the temperature in Manchester is that people are not being held accountable for their criminal behavior. And that's the reality.
Chief, a lot of what we hear and the public hears is from the media. And sometimes it's not exactly accurate. Could you help? There was a case that we saw just a few weeks ago where there were two brothers arrested. I believe it was for a shooting in Manchester, and the judge let them go. And everybody's like, how is that possible? Could you give us a little background, if you could, on that case?
It's an open investigation, so that
can't,
would be
okay.
slippery for me to get into that. But we do have people that have committed gun violence who have been, now granted, a Superior Court judge may set a cash bail that the person is able to meet. Okay, then,
Yeah.
But there have been cases where people have committed violent offenses and have been released on extremely low bail, or in some instances, PR bail. So,
In your opinion, if the district attorney had the ability to appeal, which they currently do, but they don't appear to take advantage of it very often because the offender's already gone out the door.
I think Mr. Shear brought this up before, and I do agree with him in terms of revoking people's bail.
Yeah.
Yes, that happens at the district court level. But at the Superior Court level, at least in Hillsborough County, the county attorney's office or an assistant county attorney has to file the motion to violate the person's bail. So yes, we provide them with the report and the information and say, hey, Alan Aldenberg was out on bail out of Superior Court. He reoffended on a violent offense. Hey, file the motion. I think that's a great question for the county attorneys. In those cases, how many times are they exercising what's currently available to them to go ahead and do that? I'll be frank. I mean, I had a conversation with an assistant county attorney, or one of my people did a couple weeks ago, and he was not even aware that
He could appeal.
he could do that. All right. So that's concerning.
Yeah.
All right. And I think that's probably where Mr. Shear and I agree. Maybe we
Well,
don't. I
one
don't know.
spot
Is he nodding his head? I don't know.
Well, what I was getting at is also, what if a judge says, okay, I'm going to let someone go on one of these crimes on PR or extremely low bail, because with the change from felonies first, everything's going to end up back in the district court
Yep.
originally.
Sure is.
And if the district court just says, okay, PR, and the district attorney had the ability to appeal to the superior court, and as part of that, the person would be held until the appeal versus just walking out of the district court. Would that, do you think, be helpful?
I mean, once that case is, once felonies first and goes into effect, goes back to district court, and you have that probable cause hearing in district court, and then the judge finds probable cause, the case will be bound over to superior court. So the whole case goes there. I would defer to an attorney on that if they would then want to, argue for a bail hearing. But usually requests for bail hearings come from defense counsel to have the bail changed.
Okay.
Yeah.
All right.
Yeah, the felonies first thing is going to be interesting. That's a whole nother topic.
One thing at a time. Any further questions for Representative Wheeler?
First of all, Chief Aldenberg, thank you for your time and your testimony. Can you ensure that the data that you compile around people getting arrested distinguishes between judges who have released them and the bail commissioners who have released them?
I can certainly do my best.
Thank you.
Again, I think the tracking system at the courts needs to be enhanced. I think we tried that last year, I believe, or because that would really, so that we're all on the same page on one system. I know it's going to take a while to get that to where it needs to be, but then that would provide you would be able to get that in real time. I would believe in the future, because those are great questions.
Absolutely.
Yep.
And thankfully, Chairman
I would want to
Roy's-
know it too.
Yeah, thankfully, Chairman Roy is really passionate about upgrading the system, so hopefully we'll get that done.
And I would assume the information that you have is going to be pre-arraignment anyway. Are you tracking these cases all through the?
No, all the stuff is pre-arraignment. Yeah.
Thank you.
And I'm pretty confident. I'm very confident in our system and our numbers.
Thank you, Chief.
So I think what I owe this committee at some point, Mr. Chairman, is the deeper dive onto those 1,500 I mentioned, if you would like that.
Absolutely. I mean, that's a startling number. 1,500 out of 58 that are already on bail is germane exactly to what we're here for. So yes.
But I think you need to know how many were violent and non-violent offenses.
Yeah.
And we'll also send the committee that program that's currently taking place at the Hillsborough County House of Correction. So you can have that information as well.
Thank you.
Thank you for your time, ladies and gentlemen.
Thank you, Chief. Is there anyone else here from the law enforcement community that would like to testify? No? No? Okay. At this point, I'd like to hear from, I think, if he's willing, since I see him, Professor Shear, would you like to address the committee? I'd like to get all aspects and views. Sorry to put you on the spot, but I want to make sure we hear from everybody.
Fair enough. My students put me on the spot all the time, so. I'll give my standard disclaimer. I'm a professor at UNH Law. I'm also elected police commissioner in Portsmouth. My statements today and always are mine only. They are not. They're not the opinions of UNH Law, University of New Hampshire, or the Portsmouth Police Commission. I'm sorry, I thought I was. Boy, that's unusual for me. A couple preliminary points. Number one, the bail system has never been designed, nor it should be designed, to hold people accountable for their crimes. That's what the subsequent criminal justice system is about. I appreciate the immense difficulties that victims of crimes suffer, and how hard it is for them in so many different circumstances. But I think anyone who represents to a victim of the crime that the bail system will make sure that the person who is alleged to have committed the crime will hold them accountable. They're misrepresenting that to a victim. The criminal legal system as a whole is designed to hold people accountable, but not the bail system at the front end. And that I understand people's frustration that accountability is not as doesn't happen as quickly as it should in many circumstances, but that's not because of problems with the bail system. That's because of problems with other parts of the criminal justice system and the resources that are in place. So point number one. Point number two, I appreciate Chief Oldenburg's comments that about those who are struggling with substance abuse issues or mental health issues. It's really, the bail system has never been designed, nor does it particularly work well, to address those issues as a part of the system. You know, the bail system, as a constitutional matter, has always been viewed as having two purposes. One, to protect the public from dangerous people while a charge is pending. And two, to make sure they show up for court. A lot of, there's an infinite variety of bail systems across the United States. And they all, almost all of them try and do it a different way. There's 51 different bail systems in the United States, the federal system and the 50 states, plus there's tribal jurisdictions who have their own system. So I think there are counties in New Hampshire, for example, Stratford County, which has a lot of resources because they house and get paid for housing a lot of federal inmates. They have a very sophisticated pretrial services program, where a judge can say, well, I'm going to let you out on bail. You need to engage in this system in this way and that way. And those tend to be much more effective than counties without formal pretrial services. I won't say, I think it's obvious why. But when it's a county that's trying to piece together ways to deal with those who are mentally ill or suffer from mental health issues or substance abuse issues or who are homeless, the bail system just doesn't work well that way. And I understand the general public's concern, police department's concerns of what do we do with these people? We've always struggled. I've been at this bail stuff since 2017, and we've always struggled with how to deal with those societal issues, and how much we really can ask of a bail system to deal in an immediate sense, or certainly not a long-term sense, with homelessness, with those struggling with mental health issues, those with substance abuse problem. I think, most people who deal with homelessness know and try and address those issues, know that, and all the research says this also, that the most important thing to deal with homelessness is finding ways to house people. That's the key to dealing with homelessness. Obviously, that doesn't mean housing them in the jail. So I make those 2 points. In terms of the specific crimes, I think that the list that is in what was last session, the Susie bill, or that which has been in the in past bills put forward by Senator Bradley is too expansive. You know, I'm an advocate of the list only including felonies. I think that is that's a better system. It's less inclusive. I think this committee has heard in the past from the court system, when that list includes misdemeanors, that means the court system is going to have to deal with, in short term, 3 to 4,000 more hearings, and it's a profound resource drain on the court system that they won't be able to handle. So I think including misdemeanors on that list of crimes is a mistake, and it's a mistake for resource reasons. You know, some of the crimes that particularly when it's a misdemeanor, particularly when it's a person who's the first time they've committed a misdemeanor, it's very unlikely they're going to get jail time on those offenses. And if they end up at the front end being held pretrial, they're going to end up serving time that they wouldn't serve if they were convicted and sentenced on the case. I also am an advocate of finding ways, and I think the concern that the police and Senator Bradley have expressed that gave rise to that list of crimes in what's now Senator Soucy's bill before the committee. I think that a system that solves that problem is one that gets individuals in front of a judge quicker than the current system does. That way, a system that has a list of crimes for which the person will not see a bail commissioner, but they will see it, and they are held until they see a judge. That's a much more palatable system to me if they see a judge within 24 hours. Whereas the way it is now, if that were to pass with that list, you know, if they're arrested on Friday evening, they're not going to see a judge at the earliest until Monday morning, or if it's a long weekend, until Tuesday morning, depending on the court scheduling. So, you know, I think that's one of my fundamental problems with grafting on that list of crimes to a system as the way it works now, is people sit in jail too long on circumstances where they otherwise might be released, waiting to see a judge because it's on those list of crimes. If we shortened that period of time to 24 hours, then you know, that list of crimes is, I think, that list of crimes with only felonies on it, I think that's a palatable and manageable list. You know, and I have, in the ideal world, I have the bail system as I was designed it, but you're not here to listen to me talk about the ideal world.
Professor, if you could, I don't mean to interrupt you, but could you tell me which on the list are misdemeanors? I'm looking at the list. Do you have it?
I do not have it in front of me from my memory, such as it is.
I believe Chief Alden is going to give it to you.
It's an uncharacteristic.
Thank you, Chief.
I will note for the record that Chief Halberg said he agreed with me on something earlier. So.
We have that on tape.
Thank you. I appreciate that. We'll edit that out. Please do. Domestic violence. Some of them are misdemeanors. I believe some of the trafficking in persons can be misdemeanors. I am uncertain as to the computer pornography and child exploitation. You know, I'll be straightforward. My list would be homicides, first-degree assault, second-degree assault, felony domestic violence, aggravated felonious sexual assault, felonious sexual assault, kidnapping, felony stalking. Stalking is another one that frequently is a misdemeanor. Trafficking in persons, felony trafficking in persons, Manufacture of child sexual abuse images, I would not put on this list. Possession or distribution. I think those are less inherently dangerous in the immediate sense. You know, if we release somebody from on bail on possession of child sexual abuse images, I don't think there's any tangible enough danger to other people while that person is out on bail. That said, manufacturing child sexual abuse images certainly is a very dangerous crime. And felony computer pornography and child exploitation. So that's the list that I would recommend to this committee. I think that it would reduce the chance that people will be held on crimes pre-trial that they wouldn't get jail time post disposition of the hearing, post conviction, assuming they're convicted, number one. And number two, it would reduce the cost to the court. I would add one more thing. There is some data out there that suggests that in the research I've done and some testimony I heard from both the court system and the public defender program several years ago, in a study committee involving the Office of Cost Containment that collects money from poor people who are appointed counsel. There was some evidence that somewhere between 25 and 35% of all criminal cases in which counsel is appointed end up being dismissed. So whatever this list contains, and if it results in people being held pre-trial, there's an uncomfortably large number of people who are going to be held for crimes that eventually will get dismissed or for which they will be found not guilty. So that's another check on how expansive we want to make this list. I appreciate that the concern should be with this list in terms of thinking about dangerousness. How dangerous are they going to be while they're out on bail until this case is disposed of? It's not a more cosmic, is this person in general a dangerous person? It's while they're out on bail, the point of bail is, are they going to be dangerous to themselves or others while they're out on bail with this charge pending? So those are my thoughts on this list. More than willing to answer questions.
Thank you. I've got a question. It's not necessarily pertaining to the list, but it's to the issue of getting the bail commissioners paid. You mentioned the Office of Cost Containment. If a defendant were released and it were ordered by the court for him or her to pay the $40 first before any fines, restitution, or anything else, would the Office of Cost Containment be the ones who would go after them for that, or would that be the court trying to maintain follow-up?
That would be the court. The Office of Cost Containment statutorily is set up to collect money from people who have been convicted of crimes for which they had a lawyer appointed. I have my own concerns about the office because the true nature of the office is let's collect money from poor people who've been appointed lawyers because they're poor. There's a certain measure of inconsistency with the whole idea behind the Office of Cost Containment. Separate topic, not for us to deal with. But I think it would be the court, if they were ordered by the court to pay the $40, it would be up to the court to enforce in some fashion, whatever they choose, the payment of those $40. I'll just add this, not intending to confuse the issue, but it will. There's an interesting moral question of if somebody's arrested for a crime, they don't have the $40, they're ordered to pay the $40, and the charge against them is later dismissed or they're found not guilty. do we want the system to still collect the $40 from them? They're not the ones who chose to be arrested and go in front of the bail commissioner. It's an obligation that it was imposed on them by the fact that they were charged, involving a charge that would later go away. There's a inconsistency there that it's a wrinkle that probably is worthy of attention. But yeah, it would be the court. The short answer, which I usually don't give, is yes, it would be up to the court system.
I might agree if they were found not guilty. Dismissal doesn't by any stretch mean that they're not guilty. And I think that it's a service that they're availing themselves up. Correct me if I'm wrong, but there's no constitutional right to bail. There's only a constitutional right to not have excessive bail. So if that is correct, they have the option to stay in jail if they want till the morning. If they avail themselves of the service, it seems they should at some point have to pay for it. Or is that, did I just open a large constitutional can of worms?
There's a can of worms there, and I won't address the can of worms, and we can fight in some other context over what the meaning of a dismissal. Sometimes a dismissal means the prosecutor looks at the case and says, boy, this is so bad a case, I'm not going to trial and risking getting a not guilty. That kind of dismissal is one thing. A dismissal that's a part of a multi-jurisdictional plea bargain is a whole nother thing. So, let me add one more thing. And I've raised this with some on the committee. The police have the authority on misdemeanors and violations to, instead of arresting somebody and going through the bail commissioner process, to the extent they do with misdemeanors, usually they don't with violations, to summons the person to court rather than to take them through the temporary custody, the arrest, and a bail commissioner. Embedding in the bail system let's call it a preference rather than make it mandatory, but a preference in misdemeanors for the police to summons that person to court rather than having them have to go through the bail commissioner process might save everybody time. I mean, there's some potential downsides to that, but I throw that out as something for the committee to think about.
I worry that might end up though in just a slew of default warrants, because if someone's homeless, I don't know how they would get their mail, but there is something to think about, I think, in that.
Yeah, I the way I would set it up is there would be when they were summoned, they would be summoned for a particular court date. The summons itself, which they would be given in hand, the police would have to coordinate with the court system on this, but have a list of court dates that people could be summoned to for an arraignment on that misdemeanor. Then again, the police would have an option, depending on the misdemeanor, if they wanted to arrest a person, see a bail commissioner, and ask for a lack of to be held without bail. That option should be there still.
Thank you. Representative Sytek?
Mr. Chairman, as I said before, I'd like to testify later, but this is a great opportunity. When do I ever get the chance to add something to Professor Shear? And that's this.
Don't feel the obligation.
Well, I understand. The thing is that the police are aware of what you've said. They don't choose, as you said, to implement it. But when it does come in, why they want to bail sometimes is you can't, with a summons, issue bail conditions. So that's why they like the bail process.
And I think you could amend the current, I think it's 597.14, or it's 594.14, or I can't remember the exact statute number. I think you could amend that to have, with any summons for a misdemeanor to a future court date, a set of statutory conditions that accompanied the summons. Just another thought. Welcome to the bail system.
Representative Muse?
Yeah, first, just a comment for the chief. It would be enormously helpful if that data that you're going to provide us actually would somehow get correlated to the list of crimes that are in SB 242 to whatever extent is possible. That would really help us see where the biggest pain points are, areas that maybe are less relevant. Having data like that, and it's always really hard for us to get data like that, would be enormously helpful as we try to finalize the list. The other thing that I wanted to ask you about is, I know one of the problems that has been kind of an ongoing issue with bills that have listed these crimes is either the written in wording that there is a presumption of dangerousness, or the fact even when you take the word out, there's a presumption of dangerousness. Does reducing the time that somebody can be held without seeing a judge, does that basically make that issue go away? So if it's less than 24 hours,
If it's 24 hours or less, substantially, yeah, it makes that issue relatively speaking, dissolve. Constitutionally, you can probably, it's pretty straightforward that you can hold someone certainly for at least 24 hours without having them see a judge. So yes, it does reduce that time. So, that's an additional benefit to reducing that time. And of course, that's a conversation with, I think, as Chair Roy had expressed, that merits a conversation with the court system.
thank you.
Professor Shear, just while I have you here, one of the main issues we're going to be addressing, and this applies to you you have experience in the research department with our courts recently. What do you think the need is for us to just, I mean, I know they have J1 and some other systems of just starting from scratch and implementing a broad, comprehensive IT system that links the court, the police, probation, parole, everybody real time, and finally get us all where we need to be, and would be able to allow the public to come in and make requests for data that would actually be accurate without having to go to every different courthouse in the state.
As I said before to this committee, in my efforts to, sometimes vain, sometimes slightly less than vain, to provide partial data to the court best I can, given the difficulty that the court system provides in extracting any data from it. I think it's essential for reasons related to bail and for reasons related to other parts of the criminal legal system. I think ever since I started thinking about bail and working with many legislators and others about bail, we always bump up against the lack of data problem, because the court system has only a case management software system. It doesn't have a data collection system, and that's a fundamental problem. Nor are any of those, since they don't have a data collection system, it's not connected to the police or other significant, the court system, to the daily court system. So I think that's essential. I know Chief Halberg and others are very aware, it's discussions we sometimes have on the Portsmouth Police Commission, that the communication problem between the police and the prosecutors and the courts, so that prosecutors know what the background of the individual that's in front of them when they are dealing with that person at a bail hearing, which is their first encounter. The description that Chief Aldenberg gave, a conversation with an assistant county attorney, is just outrageous that they weren't even aware that they could file a motion that, as I understood what he said, they weren't even aware they could file a motion to revoke bail. Yeah, members of this committee have heard me talk about, the statute's fine, the bail statute's fine. It's just gotta be, people gotta use it. I mean, there's mechanisms for people who are rearrested after being out on bail on a misdemeanor or a felony. There are plenty of mechanisms in the bail statute as it is for them to be called to account for being rearrested. Is just prosecutors. It's not the police's fault, except in those jurisdictions where there's a police prosecutor. It's the prosecutor's fault. They're just not doing it. Maybe it's a staffing issue. What the story Chief Halberg told me, testified to you, just like, that's an education problem. Hopefully it wasn't one of my former students who said that.
Well, this would be a good time for me to say this, and I want to make sure that the members of the committee and the public, we are not we're not blaming any particular, especially we're talking a lot about the courts, and it always strikes me when I watch a State of the Union where the courts have to sit on their hands whilst somebody berate them because they're not supposed to have opinions and they're not supposed to be defending themselves. So I want to make it clear, we're not bashing the court, we're not bashing the prosecutors, we're not bashing anybody. We're just trying to fix a problem. And if a district attorney wasn't aware of that, then I don't think that I'm not going to advocate that we make them go to school again. I just hope that they maybe get wind of it and they realize they can. But right now I'm concerned with this information system, and it seems like everything we're discussing is predicated upon someone having the proper information. So a DA who doesn't know someone's full record or may not even want to appeal it because it seems like, all he's dealing with is a case in front of him. And a bail commissioner not being able to see that someone has a history of defaults can't make an informed decision. So it seems like it all's heading back to that information problem.
I agree with you, Representative Roy, and more broadly, but in vein with what you're saying. I mean, I've had concerns about the bail statute being blamed for all the problems in the system, and I think there's a lot in there that, if used properly, it would be fine. That said, I think the chair's goal and this subcommittee's goal to look more comprehensively at systemic problems is going to involve, the court system putting a little skin in the game and making some changes, prosecutors doing the same thing, the public defender's office in terms of staffing putting some skin in the game, the police putting some skin in the game. I think everybody's got to be willing, if we want to make the bail statute work better. I think everybody's got to be willing to change. Everybody. Of course, I'm a law professor, and so I can go back to my ivory tower.
Agreed. I just want to make sure that we all, including everyone who testifies, agrees, so that when we request the money it's going to take to fix this, that the whole system agrees that it needs to be fixed, and it's not just this committee trying to fix it. The whole system agrees. Representative Wheeler.
Thank you, Professor Shear. And I agree with you, Chairman Roy, that we're not blaming anybody. This is a multifaceted problem, and it's a systemic one that needs to be addressed. Would you say to that point that HB 46 FN fiscal note, the bill put forward by Ranking Member Harriet Gothright, which would have replaced bail commissioners with magistrates, would that go anywhere in helping people get in front of a judge and not be held without trial?
It would. I've thought long and hard about that, and I appreciate the expense of that, and I appreciate the time it'll take to implement that. I'm supportive of that idea. I think there may be other options that might be cheaper and quicker to implement that would have the same effect. But that's as much, talking with the court system about what's possible, what isn't possible. I have no philosophical or ideological problem with the magistrate judge system. I'm more than willing to consider there might be other possibilities that would get us, at least for bail purposes, something good enough and not as expensive.
Thank you, Professor.
Thank you.
Is there anyone else here wishing to testify, either from law enforcement or from the defense bar or the district attorney? Anybody? Seeing no one, I'm going to ask Representative Sitek. Oh, wait, what do we got?
Good morning. Mr. Chairman, members of the committee. My name is Chester Scott Jordan. I'm the prosecutor with the Derry Police Department. Formerly, I was, excuse me, I was a police officer with the town of Henniker back in the late 80s, early 90s. Then went to law school. I was a prosecutor with the Merrimack County Attorney's Office, the Hillsborough County Attorney's Office, and the Rockingham County Attorney's Office prior to coming to the Derry Police Department. The bill as proposed is a step in the right direction in regards to giving all parties time. And that's the issue here. It's the time to look at the criminal history. It's the time to reach out. Once again, we don't have a system where I can print up, and the Commonwealth does, Massachusetts, probation, parole, they prepare a report for the court. And that lists everything from juvenile offenses up, if they're on probation, what is the status of the probation, what the offenses are. Here, I can have my dispatch run a record check. Then I have to review it and look at the history, look at the sentencing. And then I have to look up to see, okay, I think he's still on probation. Now I make a phone call to probation. Is this guy still on probation? Who's a probation officer? So these are all things that have to be done. When you're calling in a bail commissioner at 2 a.m, he's not going to have, or she's not going to have, any of this information. What we're asking for in this bill, and what the bill is proposed, is under these crimes, the person will be held. They're going to come in, they're going to get a fair hearing in front of a judge. In other words, they're going to have a defense attorney. That defense attorney is going to have time to talk to that person, get their personal history, and be able to argue that intelligently to the judge. The prosecutor is also going to have the time to do what I just said, to review the record, to look at the record, and then investigate, make some phone calls. And once again, I can present my case to the judge, the defense can present theirs, and the judge can make an informed decision. That's what this bill allows for.
Thank you. If we did have a BOP system like that, would it not make it a lot simpler, easier, and safer? I mean, you referenced the Board of Probation in Massachusetts, the record check. I believe it covers all of Mass juvenile, and you can do a triple I as well. Mm-hmm. If you had all that information available to the officer on the street, the bail commissioner, you as the police prosecutor, you could see clearly default. I mean, it shows everything, all the history, and you would know if they're on probation, if they're on parole. I believe the Mass system, if a police officer runs a record check on a parolee, that system notifies the parole officer that one of his parolees has been bopped, his record check's been pulled, which triggers him to call his parolee and say, "What are you doing?" Or call the police department and say, "Why were you running my guy?" So I continue to go back to, I think that rather than this right away, we need to get that information system fixed as part of this.
What you're looking for is a huge.
It is.
It's a huge take, and it's momentous for a state, especially a rural state like we are. Mm-hmm. I've worked in those small police departments. Yeah. I can tell you that at 2 a.m, when I've got somebody arrested for domestic violence, for just assaulting his wife, and I've taken him into custody, I brought him into the station. First of all, I'm the only one at the station. Okay, I walked in, I unlocked the front door, we walked up onto the porch and then into the PD, because it was a house, formerly. I've got the prisoner there. I call the bail commissioner. The bail commissioner comes down. Now, I've radioed into dispatch, which at that time was at the county. They do not fax me the record. They do not, at that point, I'm dating myself. We didn't have email. It wasn't emailed. So there was no way for me other than them on the phone telling me what it is, and I'm writing down as much as I possibly can. Even with a connected system, I still think I'm not going to be able to get that. We're talking about small towns that just don't have that capability or ability. Where we do is giving the time, that 24 hours or that 48, depending on over a weekend or whatever, is giving the person time to be able to get all that information to be able to come in. And as I say, this is not one-sided. This now allows a defense attorney time to sit down, whether it's going to be 20 minutes, a half hour, an hour, to get that information before we have that hearing. We come in Derry, where our time is, we're at 9 o'clock. And then it goes from different courts throughout the day for the arraignments. So depending on the time, people, the defense attorney and the prosecutors will have time to present that once again. So the court has all the information to make an informed decision. And that's what this bill will allow.
The Derry Police Department has a LEAPS terminal, I assume, correct?
I'm sorry.
The Derry Police Department has a LEAPS terminal, I assume, to run the records. To do
Yes, we're able to run it at our station and print them out at our station.
Do you have any idea about how many departments in the state are not interconnected or have not the ability to run a record check?
That I could,
Ballpark.
I want to say less than 50%, probably, well, a lot less. I would probably say you're down to a quarter, 25%. Is Chief here?
Okay.
But the majority of police departments, they're not their own dispatch.
Right.
Dispatches are run by the counties or a bigger community. So they don't, those communities who have the dispatch, those will have centers. They will be able to run those records.
Mm-hmm.
But that police officer cannot go back to the majority of the small towns, the part-time police departments. They do not have the capability of running records out of their office.
Or have a mobile data terminal in their vehicle.
As I say, it depends on their connectivity. And I mean, when I was a police officer, granted, we're talking 20, 30 years ago now, actually 30 years ago now. I had a portable that was this big, and we used it to throw at people because that's all it was good for. I mean, you didn't have any connection.
Okay. All right. Thank you. Any questions for you? Go ahead, Representative Stone.
One of the questions, and I can't recall, is breach of bail a standalone charge in New Hampshire?
No, it is not. It's criminal contempt. That's what we charge it
criminal
as.
contempt is, in your experience, do many officers utilize that?
There are, well, quite frankly, there are departments who charge breach of bail. We don't believe that is under the statute, but it is charged. Criminal contempt we do charge, and we do it on a regular basis, yes. I don't know how, I would say it's underutilized. It's really not charged, but it is a criminal contempt of the court. And the problem with that is the criminal contempt is for the actual court. So if somebody's out on bail, say from Manchester, and we stop them in Derry for a violation, then we notify Manchester because they would have to file the criminal contempt because it's a contempt out of that court.
Thank you.
Thank you for your testimony.
Thank you.
Representative Sitek, would you like to address the committee? For the purposes of the committee, Representative Sitek is not a member of this subcommittee. He is here just to provide information and to help us because of his experience as a bail commissioner and his many
Hi,
years in
thank
the
you
House.
Thank you for listening. I'm
Hold
John
on a
Sitek.
second, Representative Sitek. Yes, sir.
Just could, for us back here, could all of you up on that line speak up? Anything.
Anyone in the back row that can't hear, please feel free to move to the front row and we'll try and talk a little bit louder. And we just, the representative kindly just turned up the speaker, I believe.
Okay, I think what I want to do here is to present a bail commissioner's point of view, I think I can speak for many of them. I know 4 personally, I know a dozen through our meetings, our yearly meetings. And I don't think I'm talking, I want to be careful not to overstate anything. I want to, Chief Halberg's gone. I did about 10 bails in Manchester and they really treated me right. So it's nice to know. I wish he had heard that. I'm also mildly annoyed at Professor Shear because he said a lot of the things that I wanted to say. In particular, what he talked about and what I'm going to argue with Prosecutor Jordan about is the front end, what the bail system does, what it's intended to do. It is the front end. It's not a judging of innocence or guilt. And what, if you follow the dynamic of today's discussion, Representative Muse opened the door and Representative Gathright piled right in on conflating the overwhelming problem of substance misuse. Chief says, we let them out, where do they go? What do we do? And Professor Shear corrected that to, that's not quite what that's not at all what the bail process is about. And I want to focus on the bill from, as I said, from a bail commissioner's point of view, even though those problems are so overwhelming as to almost blunt what anything we do here, because we're talking about lives too, over drugs. Oh my God. One of the problems I have is with what the chief said and the prosecutor has said is, if someone, I don't know what they're calling it, but if you're out on bail and you commit a crime, you do not, the police don't have to call any bail commissioner. They can send them to, in our case, Brentwood in Rockingham County. I don't want to be called. If there are certain other crimes that already exist that we can't bail. We can't bail murder. We can't bail fugitive from justice. And we can't bail violations of a restraining order. And that's perfectly fine. Now, why I have a problem with what the Prosecutor Jordan has talked about is this. Sure, the records aren't great. We don't know who's on bail from Manchester when Derry picks them up. I understand that. But whenever I'm bailed, do a bail, I get the person's history. Now I look at that history and I say, it's largely not relevant. I am there to judge flight risk. Please don't lose sight of that. And danger to society. I don't care what he did in 2017. I don't care if he has defaults, unless they're excessive. When I talk to people, they have the right to a face-to-face. I didn't get a letter. Well, maybe he didn't. Maybe he's not telling me the truth. I moved. He has a side to his story on a default. I'm not going to. So I want to tell you from our point of view, from a bail commissioner's point of view, we're very careful. I want to talk about one crime in the bill, and that is the domestic violence. We see lots of them, and no, every judge, everybody, they're not going to incarcerate. They're going to say, are you going to obey the criminal bail protective order? And if they feel that they're going to go live with their brother and they're not going to go with their wife, and they'll sit for a civil standby to get their underwear so they go to work the next day. Everybody does that. I have my copybooks if anybody wants to see them later, the 3,500 bails I've done. I've done maybe under 10 in my history of a felonious domestic violence. Felonious is he put his hands on her throat. He shouldn't do anything, but it isn't that he had her on the floor, choked her to death. I mean, it's all done on allegation. Now, The 2 in the morning business. Look, at 2 in the morning, I am deciding flight risk, not their history, not a lot of, are they going to show up for court? Are they going to misbehave if I let them out? That's what I'm judging, not all these other things that are useful, interesting, that occur farther in the process. I'm going to, so I wanted to talk about that one aspect. I'm going to finish with a bold statement. I don't really want to say anything further because Professor Shear's idea of felonies, and maybe not all felonies, I'm talking about maybe violent felonies or where you suspect that there's going to not obey a restraining order or they're going to continue behavior. But now we're fine tuning. I have his list as he's proposed is okay, but I don't think the bill's necessary at all because bail commissioners, I heard the chief, I don't believe that we're letting people out on felonious sexual assault on, of course, I haven't done one as a matter of in all that time because look, when we aren't sure, and as I said, I'm speaking to people, I'm going to say to myself and out loud, I'm not comfortable here letting this person go. I want the judge to decide this. Now, I may have my own opinion, and I may be right, but the judge is final. Not because he's right, but because he's final. I'll conclude, if I may, with, or I think I'm going to conclude, I don't know, I scribbled here. Look, the first couple years I did this, I'm very I try to be, look, I sometimes talk a little flip, but I try to be careful about, we're dealing with people's loss of liberty. Come on, you just can't be cavalier about that. But so for the first couple years I was doing this, and by the way, there are very few, almost everything is personal recognizance. There are very few cash bails, very few holds. I spent 3 hours I spent in Exeter Hospital because the guy threatened 2 police departments, said, I'm going to find out who arrested me. I'm going to kill him or take him out. The guy's drunk. He was probably be all right. But I thought, I don't want to take any chances. So for 3 hours, I sat there while they tried to sober him and said, finally, we did a preventive detention. And I went home because I just didn't want to take any chances with this situation. And I don't think any bail commissioner is going to take any chances, whether this bill exists or whether it doesn't exist. But again, I said I have no problem with Professor Shear's thing. So as I said, for 2 years I tracked. No judge ever changed my bail. One did. I put a cash bail on somebody I wasn't comfortable with, but I wanted to give them some opportunity that if they knew this money was at risk, they might behave. And the judge just held them. But that's one out of, I don't know, 10, 15 that I actually chase. Once you're finished your paperwork, you go home, you don't. But I followed them to Superior Court to see. I asked our clerk locally, what happened to Joe Blow? And no judges. And I think I'm trying to speak for other, I don't believe I'm out of turn. I don't want to be speaking for other bail commissioners. They can speak for themselves. But I don't think we're too big for our britches, whether this bill exists or whether it doesn't exist. So I'm not in favor of the bill. I think if you had a compromise with Professor Shear's felonies, I wish he hadn't said so many interesting and useful things. All right.
Representative, if
I'm
you
done.
could,
I'm done.
what is your the notice that you've, since bail reform in 2018, how has that affected, if at all, how you conduct your job?
You know, the truth is I tried to do my job irrespective of that. I did not want to be incarcerating people for lack of, as indigents. I just didn't do that. I mean, somebody didn't, we were told, look, bail commissioners follow the orders of their district court judge. We see them once a year for a conference, and we'll sometimes get periodic updates. Okay. For example, Judge Corby in Salem said, don't ever bail a B. State police come with Bs. Well, I don't want to bail you, but that's their tradition. It's like no driving, just to put a bail condition. But there's some inconsistencies in the court system too. I'm not bashing anybody, but one hand doesn't always know what the other hand is doing. Look, I don't live in the ivory tower. I live in the booking room, okay? And I see this stuff, and I think other bail commissioners try to respect. You're talking about person's personal liberty. Who wants to spend a night in jail? Oh, it's only 24 hours. Who wants to spend 24 hours in Brentwood jail? I don't know. No. Thank you for listening.
Thank you, Representative. You have a question, Representative Wheeler, and then Representative Muse?
First of all, Representative Sitek, thank you very much for your testimony. I think that was incredibly helpful. My question has to do with the topic that we were talking about earlier today, and I want to hear your opinion. Maybe you can't give it. Do you think that bail commissioners should be paid for the work that they do, more so than they already are in some cases?
As I told you yesterday, I'm very lucky. It's 2 out of 10, 1 out of 10 I miss. Not so when I did Manchester, I did about 10 there, paid for half, and I'm driving from Salem for the team. I didn't want to let Manchester down. Yes, they should be paid. I mean, if we're contemplating what I think is, I would disagree with Professor Shear about the magistrate system. I think right now we're paying nothing. Imagine 10 to 15 magistrates covering the state 24/7. Really? On another, you're going to wake up a magistrate, an important person at 2 a.m. You're waking up a schnook like me at 2 a.m. I'll come in. Magistrate's going to, justice may be shortchanged there. Leave them in jail. Let them. Yes, they should be paid. I don't know the mechanism, but it's just not. Maybe not the full. I just don't know. That's an important topic, perhaps for another day. Not this. I'm trying to keep it to this bill as much as I can, but I didn't want to not answer your question.
Every time a bail commissioner testifies, we do get an education. But one of the things that always strikes me, in just hearing different people tell their stories, and this is the first time I've heard you tell yours, is it just always strikes me how much subjectivity is part of the process. So for example, you had said that having those electronic records that we've been talking about may not necessarily be helpful to you in making your decision. And it sounds like a lot of what you decide is sort of based on your impression of the person, how they conduct themselves, what they're charged with, what the police say. So what I'm curious about is the way that you approach it, is that the model for all bail commissioners, or is that the way you approach it? And what level of consistency is there from bail commissioner to bail commissioner in New Hampshire?
I can definitely tell you I don't know. I believe I have tried to be more articulate than others, but I believe that's a kind of cultural aspect of bail commissioners. I think we have another one here, or maybe two. You might ask them to comment on my testimony to see whether it's at variance with their experience, with their worldview. You said also, if I may, about subjectivity. Yes, even judges are going to have some element of subjectivity. People talk to me. I want to hear what they have the right to be heard, in my view. And many times it's just cut and dried. But there are other times that I really didn't get the letter. Please understand that. And look, there was another perhaps irrelevant story. I was called, everything's 2 a.m, it seems, but this really was maybe not that. This guy has been long record of drugs, drug misuse. He was picked up for selling. We want high cash bail. Oh, this sounds like a tough, bad customer. I come into the police station. Now, look, I normally agree with the police, but I come in, I want to talk to this guy. When he asks for a bail commissioner, what comes out of the cell but a sad sack? Near derelict is too strong, but just, this is not a drug deal. He must, I don't know what the deal was. He probably had wanted to buy a fix or something from somebody else, or maybe offered to sell something. So I'm looking, this guy did not warrant it. You talked about subjectivity. That was my subjectivity. This guy was not worth a felony charge. I can't change the charge that the police make. That's their business. But I can set conditions of bail. And I check no drug use, that for your own good, please don't do this. And let him go on personal recognizance. This was not, it was subjective, but I believe I did the right thing. Furthermore, as I want to repeat, you see this judge 12 hours later, he's going to do what we do. That's a bold statement. Every one of you, I'm sorry, every one of you has the capacity for making the same kind of judgment a judge does. You're all thoughtful adults. You've read newspapers. You have some sense of the law. You make a judgment about people. What does the judge do? He's the final word. That's all.
Thank you.
Thank you, Representative Sitek. At this point, we're going to take a 30-minute break and reconvene at 12 o'clock, when I anticipate us to go probably about another hour today. After that, when we get back, we're going to actually start delving into these crimes and discuss amongst ourselves their relevance and how we can possibly deal with them or other alternatives. So with that, enjoy your short lunch. We're reconvening a little late. I apologize. Yes, a lot of people were very hungry. At this point, I would invite, we have an alderman here from Manchester. I would invite her to come up and address the committee if she would like to.
Thank you, Chairman. Oh, sorry, a little loud. And committee members. I'm Chrissy Cantor, a concerned citizen and an alderman in Manchester. And I'm a victim of stalking, and I definitely don't want it taken off the list. And I'm highly concerned about really helping people and slowing the process to get people to get help that they need. And I know as a victim of stalking and so forth from a previous time that it escalates, and it's a known fact that you're not born a pedophile. There's a process that it elevates, and that is my biggest concern is stopping that process and getting people the help that they need.
Thank you. Could you tell us if you could put your alderman hat on for a second, what are you seeing and hearing in that role as far as what's happening in Manchester relative to the criminal activity and the issue surrounding bail?
So what we're seeing is people are let out right away and committing more crimes, and it's affecting everyone's livelihood, and businesses and people are concerned about their safety in Manchester. And there's been like 700 people that have been arrested a second time after they've been out on bail. So it's really affecting feeling safe in Manchester.
Thank you. Does anyone have any questions of the alderman? Seeing none, thank you very much for sharing with us.
Thank you.
Okay. Mr. Knack, did you want to address the committee? I know that yesterday and you didn't really want, but today, go ahead.
Mr. Chairman, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack with the ACLU of New Hampshire. The handout I gave you, I know y'all, it probably looks familiar because I'd given it to y'all, or at least part of it last session. And the reason I'm giving it to you today, and it's about a bill that's not specific, or it's one of the bills before, is because both Professor Shear and Representative Sytek mentioned under existing law, the myriad ways that people can be held if they are in violation, if they commit a new offense, et cetera. And so I just wanted to point specifically, we actually went through the bail code, which is quite long, and pulled into just kind of easily digestible sections. So it's like the third page in. We go through and list just the verbatim code section. So I literally just copy pasted, so it's word for word. These are all the ways in current law that people can be held if they violate, if they commit a new offense. Also includes, I believe, I forget who referenced, but around restraining orders and how there's no court judicial involvement, how people can just be rearrested and detained. So all those are in there. And I think, as Professor Shear mentioned, it was quite telling that it sounds like what's happening in Manchester, the fact that it sounds like it's just a public education problem, that prosecutors don't know that all these tools exist in current law. And so I think, a really great first step would be to do education, to, let folks know who are in the judicial system about what the current law is, what it isn't, what they can use, to ensure that we are not defaulting to just incarcerating people because people don't know what tools they already have. Also, just really appreciate the conversation we've had today about the fact that existing law or apologize, lost my place. Where is it? Oh, the fact that sorry, I just want to make sure I'm getting all my points. I apologize. So we had talked about specific criminal laws and whether we want to have, blanket holds on folks, and whether we want to have a blanket hold system, which SB 252 and some of the other bills before this, or we want to have a more individualized approach. And I think, building on what Chairman Roy had talked about last session and has alluded to today about trying to use modern technology, it is 2023. We have all this ability to take all this data and to get it to people who need it quickly. And to prioritize that so that judges or others making these important decisions have all that information before them right away, we think is appropriate. And the reason that we are concerned about some of the approaches that would just say for all these offense types, we're automatically holding you, is because, the facts matter in these cases. And so, and I don't mean to minimize the harm that some folks have felt, and some of these do accompany very serious acts that would result in these charges. We just heard from the previous speaker about stalking. And, we agree that there are probably instances where people who are charged with stalking may need to be held pre-trial. But just because someone is charged with stalking doesn't mean that it is a horrible fact in each case. And so I actually spoke with a couple of criminal defense attorneys who hear lots of these cases. And so stalking was actually one of the ones that was flagged for me. And they had talked about how it, conjures up these horrible images of someone hiding out in the bushes as like, when you think stalking, this is what you often think about. But in their practice, what they usually saw was that it involved text messages and calls, and oftentimes it was initiated by the victim in those cases. And so those people ended up being released by the bail commissioner because the bail commissioner could look at those specific facts in that specific case and say, this doesn't merit holding you. And that's what our current law, the beauty of our current law, it allows this individualized assessment for these offense types. So we have other offenses that we heard about, for example, aggravated felonious sexual assault. What I heard from talking with defense counsel is oftentimes, again, horrific offenses if they're true. But what we heard is that oftentimes in these cases, the charges are filed years afterward, where the alleged victim and the alleged offender no longer live together, no longer have contact. And so, again, the facts in those cases should be brought before a bail commissioner or a judge. They should be able to look at that and decide on that individual case whether or not someone should be held. And finally, I know we talked about this a lot, but it just came up from the alderman in Manchester, is just kind of what the facts are around public safety post-bail reform. And so again, in that packet I handed y'all, we pulled this again. This is directly from the state database on crime. So Department of Safety's crime stats list from Manchester. For Group 8 crimes, which are the vast majority of offense types, all violent offenses in Manchester, crime since between 2018 and 2020, 2021, crime is down for Group A, 13.9%. Arrests are down 33%. And for Group B, arrests are down 32%. So again, the notion that we're seeing an uptick in crime is not borne out by the actual data that the police have provided to the state. So happy to answer any questions and really appreciate the thoughtfulness that this committee is approaching this way.
Thank you. If you could, the arrests and crimes being up or down, it doesn't really necessarily correlate to whether or not someone's rearrested on a charge if they're already out on bail. These numbers just speak to the overall crime, which would not necessarily be impacted either way by bail. It's based on a whole plethora of social, economic things. Is that correct?
I totally agree with that. I think, but our concern is that the rhetoric that this is putting forth is that Manchester is this dangerous place, that these cities have become dangerous because of bail.
Oh.
And so I think, building on that point, we've heard these stories. We've seen no specific evidence that this person was rearrested, was out on bail. And, you know, when we started this conversation last session around the horrific murder in Manchester, Professor Shear actually dug into the facts in that case, and it had nothing to do with the failure of the bail system. It had to do with the fact that prosecutors did not use the tools that they had. And it wasn't even about a bail commissioner. It was judges who would release the individual.
I don't think anyone on the committee would argue that necessarily that the crime rates are not down, but we are concerned about is the numbers of people who are rearrested while they're on bail is what seems to be driving the consternation of the Manchester public, and that's the problem we have is with the data. Once again, it's how do we get it? I mean, do you have any way to get that kind of data?
Yeah, and I think there's two issues. One is why we so support your real-time bail tracking system, so that everyone has all the information in front of them. And there are other states that have done bail data collection. New York State, for one, has done bail data collection. And I think the findings there have been actually helpful from a bail reform perspective. So there's definitely models that we could take. I mean, they cost money.
Yeah.
But I think, you know, we were talking about spending money on any of these solutions. I think it would be most appropriate to put the money into things that will actually get us the data to make informed decisions.
I guess my question was kind of rhetorical because I don't think there's a way you could get the data from New Hampshire right now
Yes.
On who's been rearrested across the state on bail.
And I think one other thing to lift up as well is, and it would maybe be helpful to get someone in who really focuses on this, but my understanding too is there are federal dollars available for updating court systems. And so this also could be done potentially in a way that doesn't have a fiscal note for the state of New Hampshire.
Or at least
Or
mitigate,
minimize
yeah.
the fiscal note on the state of New Hampshire.
I'd be happy to hear anything about that. So if you have it, please send it our way. Does anyone have any questions for Mr. Knack?
I do. I do.
Okay, you go ahead. You haven't asked any questions yet.
No, I got a question. Do you believe bail bondsmen should be judges?
The bail bondsmen or bail commissioners?
Yeah.
I'm sorry, which?
Well, you talk about varying amounts in different crimes. Instead of just saying a crime, you want like different levels of a different crime. Stalking is a serious thing. Stalking is a progressive crime. It starts out at one level, it goes to the next level, it goes to the next level, just like child pornography. Starts off with pictures, but it goes up and up and up. So I don't think you can take different levels of a crime and have a bail bondsman be responsible for deciding if he's at level 1, level 2, level 3. I think all you're doing, the purpose of the bail bondsman is to protect the safety of the public. So if you have somebody that's on one of those steps, you only ask them to be detained until the point that a judge can make a decision whether that person should be released.
Yeah, and I think that's, I'm sorry.
You agree with that?
I think that's the beauty of our current system is it allows for that. If, as we heard from Representative Sitek, if a bail commissioner is not sure, then the judge can look at that case. So I think that's what we want to make sure that we have that individualized versus a blanket. And so also, I mean, I think it's important to remember that these charges are just what the police have brought. Oftentimes, prosecutors, once they get the case file, will realize, oh, this was way overcharged and will reduce. And so I think it's important that we get away from these like just, one size fits all approaches and have individualized assessments.
That kind of brought me to my next question. You think the police, follow up, please. Thank you. So do you believe the police are erroneously arresting people?
Or, I'm sorry?
Do you think the police are erroneously arresting people?
Erroneously?
Yes.
I don't believe the police erroneously, I'm not alleging that the police erroneously arrest people, but, in an earlier job, I ran the Montana Innocence Project. And so we worked to free people who were wrongfully convicted. And if you actually look at the national data, thousands and thousands and thousands of people have been exonerated because the state got it wrong. And so I think it's really important to remember that the state is not always right. And so having individualized versus blanket, I think, is better. And so I'm not saying the police are intentionally doing anything, but police are human. Everyone makes mistakes.
So it sounds like the system worked.
I'm sorry?
It sounds like the system worked. If somebody by accident gets stopped and get arrested, then it works.
No, I think the innocence case I brought up is how the system didn't work, but for the fact that there are nonprofits that have private dollars raised, those people would still be sitting in jail. The state didn't do anything to get those people out. The state actually fought all of those cases tooth and nail. So it wasn't because the system was working. It was because nonprofits came together and realized that there was a fundamental flaw in the way the state was operating. And so we still have efforts to fix laws that we have decided, even in New Hampshire, there's legislation every year around recording of police interrogations, because we know from innocence work that police, that false confessions happen. They happen for myriad reasons that have to do with brain science, et cetera, particularly with youth. And so instead of actually, I guess look at it this way. When a plane crashes, what happens? We look at all the facts. Why did that plane crash? And then we do everything we can to mitigate the chances of that ever happening again. So they'll do new safety protocols, et cetera. Same when someone dies in a hospital. But when there's a wrongful conviction, the actual opposite happens. There's no effort by the state to figure out why did this happen and how can we take steps immediately to make sure this never happens again. It's only because of nonprofit groups that any of those reforms really ever happen.
Okay, well, we're getting far afield now,
Thank you.
so that's all right. Representative Stone and then Representative Muse.
Real quickly on the issue of the data, has anything been given for this data collection involving the reduction of police across the state, including Manchester, where I'm sure they've had their staff shortages? Obviously, if you have less police officers, you have less activity and actual work being produced. Has that been put into this factor for these numbers?
I don't know if that's been put in, but this has crimes, which are not necessarily, those are often community initiated, reported. And crimes are also down substantially.
And just follow up, are these going to be any designation for multiple crimes by the same defendant?
It's the same methodology. It's the way it's been reported to the state. So I wouldn't imagine things like that. I assume the state has always used the same methodology if they're reporting it the same way.
Yeah, the data that he's given us is just data that the police reported to the Department of Justice. So whatever they got is what we got. Representative Muse.
Thank you. Something that Professor Shear said really did catch my ear, and it's the fact that lists like the ones that we're looking at become a lot less relevant if another part of the law requires people to actually see a judge within 24 hours, which he was saying meets constitutional requirements in a bunch of states and seems to be a good ongoing practice. What it seems to me that we might be able to do is to craft something that has a list of some of these crimes, and essentially what it would become is a list of offenses where the bail commissioner doesn't have discretion, but there is a requirement that if you're accused of committing one of these crimes, that you have to see a judge within 24 hours. I guess what I'm searching for is we've spent a lot of time in past committee sessions kind of reviewing the list of crimes and trying to pick out the ones that might touch on misdemeanors and which ones might be a little more dangerous than others. And I'm wondering, does that whole conversation become a whole lot less relevant if we have a 24-hour limitation? So if we basically shrink that amount of time, maximum amount of time people can be held without seeing a judge, for all intents and purposes, does a lot of this go away from a constitutional perspective?
I think Professor Shear spoke about the constitutional issues there, and that restricts or minimizes the chance of a concern there. And I would really defer to him on that answer. I think, two things from our perspective. I think while we would definitely support reducing that to 24 hours, I think it's also important to remember that for someone who's like a shift worker or a primary caregiver, 24 hours is eternity. You can lose your job. You can, your kids don't have access. I think what we'd be more, lean towards would be, under existing law, prosecutors can challenge any release order they disagree with. But the very valid argument has been brought up by those who say that, well, that person's then been released and, then it's too late. So I think, one possible avenue would be to amend the law to basically allow for, if the state says, the bail commissioner releases, the state says for X, Y, or Z reasons, we think you're wrong, we think there's a danger, because it's in that individualized case that's fact specific, that they can say we actually disagree and we want to appeal this, and that person would be held 24 hours before they got before a judge. I think that would be potentially more appropriate because it is fact specific, case specific, individual specific, and not just because someone was alleged to have committed a certain offense type. I definitely think, in all the worlds that have been brought before this committee, that would be, I think the most appropriate from our perspective. But what Professor Shear talked about of having a limited number would maybe be like a median, median position. But yeah, I think our main concern is what's been brought before this committee from the Senate, which are just, a whole host of offense types. We're talking thousands of people, no specific nexus that person is actually a danger or a flight risk. But we're going to hold them for a bunch of days. And that's extremely problematic, not only for the individual, but their families. And also I provided in the handout, also the research shows from a public safety perspective that actually makes communities less safe.
Thank you. And also thank you for the work in going through the statutes and pulling some of this stuff out for us. That's going to be very helpful.
Thank you.
Thank you so much.
Is there anyone else here who hasn't testified who wishes to testify today? Okay, seeing none. At this point, there's several other committees, I believe, that are starting at 1 o'clock that some people need to go to. I think we've taken in a lot of information today. I think that it would behoove us all to take that, think about it. And I think when we meet again next Thursday, we're going to start with a working document that we can all start to actually flesh out and start putting some beef on the bone, as it were. And just to be clear, we're going to be taking some votes, but they're going to be non-binding. They're not going to be the final votes, just so we can kind of see where we are and how far apart we are, if we are on certain issues, so we can narrow it. So I would encourage everyone to take everything we got today, all the testimony we got, do your research, talk to your constituents, see where you are. And when we meet again next week, I'm going to present an outline from at least my perspective where I think we should start. Of course, everyone's free, and actually I hope everyone add to that, and we'll see where we stand on the issue of the crimes and people being held. And hopefully Thursday we can move on. After that, Friday to start the next portion of it. Does everyone agree with that? Does anyone have anything else they want to add? Representative Sytek.
I may be close to an apology to Prosecutor Jordan. I had it wrong about the breach of bail business. I was told, not by him, by someone else. I don't have that situation, so I was over my head, and I'm sorry I said more than I should have.
That's all right. I'm sure he's okay. We'll be moving on after this. So just to, if you feel like you're ready for a meeting next Thursday, I think after that, we're going to be discussing on Friday the actual issue of the bail commissioners and their being paid and how to handle that. So that'll be the next topic that we'll be taking up on Friday. Did you have something you look like?
I just have a comment. I mean, I think it would be helpful if we had more victim statements. I think that would give a much needed viewpoint. I thank you for your testimony, but that was just one. And I think to make a well-informed choice, we should really be able to hear from the victim side as well.
I would say that from now until November 3rd, I'm willing to hear anyone who comes before the committee and wishes to offer any. So if you have someone, of someone you'd like to come speak to us,
I'll start. Yeah.
we are very, I'm running a very open deal here. So I want to hear from everybody, all sides of the argument, and then we'll come together somehow.
Thanks.
As a matter of fact, I probably am going to reach out myself to the Domestic Violence Coalition, and they will probably have plenty plenty to say on that issue. But I'm not necessarily sure, based on what I'm thinking right now, we need it for Thursday. But if you have someone you'd like to bring, that's fine. With that, no one else has anything to say. We're going to recess until next Thursday at 10 a.m.